Shalom, my name is Michael Decker, and I am a lawyer within the law offices of Cohen Decker Pecht and Brosh. Today I wanted to discuss a phenomenon which is relevant with the Interior Ministry as it relates to an Israeli citizen that is trying to naturalize a family member via his citizenship. There are various policies that deal with naturalization of family members, such as an elderly and lonely parent of an Israeli parent of an IDF soldier that served in the army, an invitation of a foreign spouse via marriage or as known in public couple. And in all these cases, the family member basically gets citizenship due to the citizenship status of the inviter, who is Israeli. This phenomenon basically arises when we're dealing with a new immigrant or even an old immigrant, but someone that was not born a citizen, someone that made aliyah and received his citizenship at some stage in his life. And basically what the Interior Ministry does is the Interior Ministry re-examines whether this person should have been a citizen to begin with, and then at times stalls the whole process for naturalization of the family member. And the logic is because if this person shouldn't have been a citizen, then it doesn't make sense to grant to a family member citizenship based on the merits of his citizenship, because he or she shouldn't have been a citizen to begin with. This policy of the Interior Ministry is very problematic, to say the least, because we're dealing many times with people, for example, a child that, someone that received citizenship as a child when he was 4 or 5, grew up here, lived their whole life here in Israel, served in the army, and now is in the age of 30 or 40, and they want to invite a spouse they met abroad, and all of a sudden the Interior Ministry says, maybe you're not a citizen, or maybe you shouldn't have been a citizen, and of course this is problematic, and that screams from the explanation I just, from the scenario I just raised right now. And in fact, our office won many cases like this. We submitted petitions to the Supreme Court at the time when the Supreme Court had the authority to deal with such matters. We submitted petitions to the District Court at the time when the District Court had the administrative authority on such matters. We submitted today, and ever since the tribunal, the Special Immigration Tribunal was established, many petitions on these matters, and we almost always win these petitions. One unique case that we have dealt with is in regards to a petitioner by the name of Avner Ne'eman, and he basically wanted to invite a spouse from Ukraine to Israel. He married her and he wanted to live with her here in Israel. The Interior Ministry basically decided that his citizenship is in question because he obtained citizenship under false pretenses. However, Avner Ne'eman was a child when he got citizenship, and he didn't submit any false pretenses. He didn't submit true or false pretenses. He didn't submit any pretenses because he was a minor when he got citizenship, and maybe his parents were the ones that, or for sure they were the ones that fulfilled the application forms and not him. In any case, the Interior Ministry dragged on the process, and they didn't allow him to invite his foreign spouse, and he lost at the Special Immigration Tribunal, and then he came to us. And basically, after years of being under examination, the Interior Ministry never submitted any proceeding to cancel the citizenship of Avner Ne'eman. So on the one hand, the Interior Ministry did not try to cancel the citizenship of Avner Ne'eman, and on the other hand, the Interior Ministry is not allowing him to open a joint life application with his wife, who is stuck in the Ukraine. Our office submitted a petition, an appeal before the District Court, and we presented our case. The judge accepted all our claims, told the Interior Ministry that they need to compensate Avner Ne'eman for his financial losses, and allowed for Avner Ne'eman's spouse to come to Israel immediately. Basically, this situation became so troubling that just recently, the assistant to the Attorney General, her name is Dana Zilber, she wrote a whole opinion on the matter, and she basically determined several conclusions. One conclusion is that when the Interior Ministry doesn't even have enough evidence or didn't keep enough documents regarding the initial naturalization of the Israeli, then the Interior Ministry cannot by any means ask for the Israeli now to submit new documents from decades ago, because basically then the Interior Ministry is asking this citizen, who's a citizen for many years, to reapply for citizenship. So Dana Zilber determined that that's out of the question. And another conclusion is that when on the face of things it's clear that it will be impossible almost to renounce or revoke the citizenship of this citizen, then also the Interior Ministry should not even pursue such a situation. However, even in this opinion, it's said that if there are heavy considerations towards the possibility of canceling someone's citizenship, then the Interior Ministry can continue with this policy. So basically, even today, there are many victims of this unfortunate and absurd policy. Of citizens that try to open family unification files or other types of files, and their applications are being stalled only because their citizenship is presumably under question. Our office dealt with many such cases, and if you are a victim to this policy, you can feel free to contact us and we'll be happy to assist you. Thank you very much for your time.